and good evening. I apologize to everyone for the delay. I was having some technical difficulties getting started. Thank you so much for your patience. I'm Debra Whitson, family law attorney, mediator, CEO of Whitson Law Firm in New York State, and also CEO of Mediated Online Solutions. And we are so pleased to have you here tonight to teach you what you need to know about child support and answer all of your questions. There's been a ton of questions submitted, so I want to get right down to business since I've kept you waiting for a few minutes, and I apologize again for that. So welcome. I want to do some basic housekeeping stuff first and just emphasize for all of you that I am an attorney licensed to practice in the state of New York only. So what I'm going to be sharing tonight and the answers I'll be giving you to your questions are grounded in New York law. So if you're not in New York, you need to consult somebody in your own jurisdiction because your laws very well may be different. Every state has different nuances, although some things that you're asking are going to be common across many states. So I'll try to point out where you really should check your local or regional rules and laws. I also want you to understand that though I'll be asking questions, I am not giving legal advice. Legal advice requires not just knowledge about the laws on the situation or the matter, but it also requires an in-depth knowledge of your situation, including where you are, what jurisdiction you're in, and whether you've got any agreements or prior court orders that may have to be considered for you to get really good, solid advice on your particular situation. So stay tuned with us. I'm going to talk to you at the end about some special promotions for those of you who do want to consult with us after or anytime after this event, not tonight, but to set an appointment for a consultation with us if you are in New York State. Also, there's going to be some other good special offers and information you'll want to hear about at the end, so I hope you'll hang on, and I am going to try to answer all of the questions, so we might go a little over the allotted time this evening. All right, I also want to tell you real quickly that I am so excited that my book called Divorce Done Right is going to be released on Amazon in just a couple of days now. So I hope you look for it there, and it's going to be available in ebook format and in paperback format or hardcover format, printed format, and soon, very soon, coming soon, it will be an audiobook as well. I hope that provides some useful information for you and your friends and your family about anyone who's considering or in the process of going through divorce, how to do it right and avoid all the most common mistakes. All right, so here we go. We're going to dive right into the questions, and they're going in the order that they were submitted, so bear with me. If you were one of the early birds who got your question in early, you'll get your answer in early on in the program tonight. And I may use these questions to elaborate and provide good teaching points when I think that a question might have applicability to a lot of our viewers. All right, so the first question says, how long someone in Essex County, New York has to pay support? And they go on to say the child has graduated high school and went to 4 months of college and then dropped out. The child now has a full-time job for almost 2 years, but doesn't turn 21 for another year. The child pays their own rent and bills, but pays rent to the other parent who owns the rental. The parent that owns the rental also receives child support. So when does child support end? Well, my goodness, there's a lot of good questions in this one question. So let me start by saying in New York State, child support can go till age 21 for each child subject to the order. So as your children definitely age out at 21, unless you have an agreement, as some divorced parents do for kids they anticipate to be in college a little beyond their 21st birthday. Some people can agree to pay support or contribute to college beyond age 21, but no court can order support beyond age 21. They can collect arrears beyond age 21, but the parents cannot be required to legally support a child who has reached the age of 21. Now, it gets complicated a little bit in this fact pattern that we have here because New York does have certain definitions for when a child can emancipate for the purpose of child support, prior to the age of 21. And so our questioner says the child has dropped out of college and has been working full-time for 2 years and paying their own bills and rent. So that would be a standard to declare the child emancipated. So if the person asking this question is the person paying support to the other parent, then you might want to consider applying to the court to have your obligation for that that under 21-year-old who's full-time employed and self-supporting removed from your support obligation. You point out that the child is earning their own money and paying rent and bills, but they're renting from the other parent. It doesn't matter. As long as they're employed and they're earning a living wage through full-time employment, or able to earn a living wage through that employment, then you don't have an obligation to support that child any longer. Okay. The next question is from someone in Texas. So, Texan questioner, please be aware that I don't know the laws about child support in Texas, but I can tell you from New York's perspective what the answer to your question would be. So, the question is, why should a father in Texas go from 55-45 custody split to a 50-50 custody split and maintain the same child support? Also, it was ordered by my judge that once my daughter starts school, I go to the standard possession order and my child support increases $300. How is this in any way ethical? So again, I don't know what Texas laws say about this. In New York, it sounds like this questioner is a father who had 45% custodial time with their child, and now they have modified their custody to be an equal 50-50 timeshare between the parents. In New York, that does not eliminate your child support, and it does not necessarily even require a court to do a downward deviation of your support because of the 50-50 placement schedule. However, if you could show in New York that your expenses have increased significantly by virtue of that change in the shift of balance of the parenting time, you might get a discretionary reduction, but it probably would not eliminate your support. And as for the part about, I'm not sure what you mean about a standard possession order and the increase in child support, I'm going to assume that that might mean that the other parent becomes the weekday residential parent, and then you're having the child less. So I suppose in Texas it would make sense to have an increase in child support at that time. Sorry I can't answer any more fully than that. I hope that gave you some questions that you might want to pose to a Texan attorney who can give you spot-on advice about your situation in your jurisdiction, okay? All right, the next question is, what is meant by past due support? So the way that's worded could potentially be two different things in my mind, so I'm going to answer it in two different ways. So past due support could be referring to support obligation that accrued or began prior to the time the person responsible to pay support began paying. In New York, we would call that arrears. And so arrears is just for what I said. It's support that accrued before actual payments begin. Past due support could also mean support that wasn't paid on time on an ongoing basis, and now there's a balance owed because of lateness in the regularity of the payment. All right, number 4, how is child support calculated? Okay, so you might want to take out a paper and pencil if you haven't already got one in front of you for this, if this is something of interest to you. So this is one of these general teaching moments I can share with all of you. So in New York, we are what's called a income sharing state. So what a support court would do is ascertain or get information or testimony about each parent's respective income. And income is from a wide variety of sources. So it could be income from earning, income from passive assets that produce revenue, like interest and dividends and things like that. And income could be gambling winnings. So there's a whole lot of things that go into defining what is parents' incomes. In New York, we add those incomes together. We subtract any Social Security tax, Medicaid taxes, or Medicare taxes, and any self-employment taxes for self-employed individuals who pay into the Social Security system in the form of self-employment taxes. We take those taxes off, and that gives us what's called a combined parental adjusted child support income figure. Then the court would determine from that total combined income what percentage of the income came from parent one and what percentage of the income came from parent two. And each parent is deemed obligated to contribute a certain percentage of their pro rata share of the combined income to the support of a child or children. So if you have one child in New York, the total percentage applied to the combined parental income is 17%. For 2 children, it's 25. For 3, it's 29. For 4, it's 31. And for 5 or more, it's 35%. So that's what's called the presumptive amount of basic child support. And basic child support is just a sum of support. So typically, the non-custodial parent is ordered to pay their presumptive amount of basic child support to the custodial parent. And on top of that, the parents could be required to share in proration to their respective income contribution to the combined family income for the cost to cover children on health insurance. So maybe in some situations, the parents have acquired health insurance coverage just specifically for children. In other situations, the parent may have employment that provides for health insurance options, and the parent has opted for a family plan or a parent plus child or parent plus children plan. So the difference between the parent covering him or herself and adding the children to the plan is a shareable expense between the parents. Other shareable expenses are out-of-pocket expenses for childcare, out-of-pocket expenses for children's education, tuition, and things like that for private education. We're talking here not college, but if you send your children to a private school or a parochial school and there is a tuition associated. So that's kind of a long answer because New York has a pretty elaborate strategy or formula for how child support is approached. The next question is, how do you prepare for a child support hearing? So I think that this depends a lot on whether you're the potential payor parent or if you are the potential recipient parent. So in New York, in many jurisdictions or counties, there are Department of Social Services Child Support Collection Unit personnel who will assist the parent who's entitled to receive child support in conducting and preparing for that hearing. And if you are the parent who's obligated to pay, in a limited number of counties in New York, you might be able to get free or reduced fee counsel to represent you. Otherwise, you would have to go down your own or engage your own counsel. But the main thing is to gather all the information about your financial condition. So the court will supply you a short form personal financial affidavit. You'll want to fill that out completely and accurately and provide the requested additional documentation, which typically includes a copy of your last filed tax return, a couple of recent pay stubs if you are employed and on someone's payroll, and information about the cost of health insurance plans that may be covering your children or child. And that information in New York support courts get exchanged between the parties. So you'll have to provide it to the court, and the other party will be provided a copy, and you will obtain the other party's information. So you will see what they're saying in a sworn affidavit about their financial condition, and you may have the opportunity to question them. And then certainly the support court judge or magistrate would also be questioning both of you to get additional information and to confirm or get underneath some of the information you put on your form if it wasn't clear. And as always, I think it's important to go into any legal matter with legal representation. So to the extent that you can engage an attorney or seek out those free or reduced costs resources for legal counsel, I highly suggest you do it because, as you're probably figuring out, there's a lot of nuances and technical things about our child support scheme in New York, and it may be a little bit difficult to go it on your own. Okay, that was a mouthful. I'm going to take a pause. And the next question says, are visitation rights and child support connected? My ex refuses to let me see my son, yet she asks for child support and insists I pay all bills. So in New York, you can press the issue that visitation should be connected to child support, and many courts would support that unless there is a reason you are being prevented from visiting, like incarceration, or a court has stripped you of your visitation rights for some reason. But assuming you haven't been stripped of your visitation rights, if your ex is refusing reasonable access to your child or children, that can be a defense to child support in a way that is complete. If you can prove that you're being unjustifiably denied access or visitation with your child, you can be relieved of any obligation to support that child. It's difficult to prove that, but that is well-founded in our law in New York, and so you might want to consult somebody about your particular situation and see what your rights and options are under your particular facts. Okay, what is included in child support is the next question. The questioner goes on to say, my ex-husband asked me to pay for things like my children's Wi-Fi, mobile phone, and school supplies. Aren't those just basic needs? And the answer is yes. All of those things would fall under the umbrella of that basic support obligation that we calculate as 17% or 25% or 29% of a person's income. And those are not add-ons. So earlier you heard me say the add-ons are for health insurance premiums, out-of-pocket or unreimbursed health insurance expenses, things that aren't covered by your insurance like co-pays, or maybe you don't have dental or vision coverage or braces, that kind of thing. And childcare expenses actually incurred, and that includes, by the way, after-school programs if there's a fee, or camps and things like that parents sometimes use in the summertime if they don't have school-based after-school childcare available to them in the summer months. And then finally, educational costs for private education of an elementary or secondary student. College expenses are handled differently in New York. It's not part of the basic month-to-month payments necessarily. Next question says, why must I still pay child support if my ex remarried? Her husband makes more than I and gives my daughters all sorts of nice things I can't afford. And you know what? I know that stings. I hear that more often than you might imagine, and I'm sorry that that's just the way it is. But a step-parent is only obligated to support a stepchild when the stepchild is receiving public assistance or some sort of public benefits like welfare, food stamps, or heat assistance or rent assistance, that kind of thing. Otherwise, a step-parent or a significant other cohabiting with the other parent and the children, their income is not really taken into consideration when calculating the child support pursuant to our statute. Those things could become a consideration when the court is considering discretionary add-ons like college expenses or private education expenses. The next question is, can child support be taken out of my paycheck? When my wages are late and I inform my ex, he threatens to take me to court and have it deducted from my paycheck. In New York, yes. Every person receiving child support is entitled to have support collected through the child support collection unit. And if somebody is on an employer's payroll or they receive regular payments as an independent contractor through somebody they regularly do independent contracting work with, their pay can be garnished, or we call it also sometimes an income execution, in order to make sure that the payments are regularly and timely made according to the schedule set forth in your child support order. Next question. My ex uses child support money that I give her to go to Florida and have expensive vacations. Can I stop her from doing this? And the answer, again, I'm sure that is really a sore spot for you, and it frankly is crummy that's what you're observing, that's your support is going towards. But at the end of the day, that basic support payment in New York's approach to child support goes to the custodial parent without any strings tied. It is generally thought of as basic support for the basic needs of the children, and that includes things like shelter and clothing and gasoline and transportation, and activities the children are engaged in, etc. But courts don't require that that's where the support goes. It simply goes to the custodial parent, and the custodial parent has pretty broad discretion about what they use that money for. Next question is, how do modifications work? I just lost my job and my ex is still demanding that I pay child support. So this is a great question. It's also a good teaching moment for a lot of situations. So I'm going to go through it in a little bit more detail than some of the more specific questions. So support can be modified around a change in income of either party, but if the income has changed by up or down 15% or more from what it was at the time the most current child support order was put into effect. So if you've completely lost your job and you don't have unemployment benefits or other things like that, maybe you don't qualify for that, then most definitely you would meet that 15% threshold. However, there's a caveat. The change in income, if you're requesting a downward deviation from your support obligation, must not have been voluntary. So for the questioner, if you were laid off or you were just simply fired because New York is an at-will employment state, employers can excuse you, let you go, fire you for any reason. If you were let go for no particular reason relating to your performance, then you definitely have your foot in the door to try to get a modification of your child support obligation. If you were fired for cause or you voluntarily left, even if you left because the working conditions were horrendous or you could no longer tolerate the stress in the workplace, that kind of thing, if you had a good reason for leaving, it kind of doesn't matter if you voluntarily left without having another job lined up to go to. I have to say, though, these are really exceptional and extraordinary times that we're in this ongoing pandemic. So in many areas around the country, but certainly in the immediate area where I practice in upstate New York, jobs are plentiful. High-paying jobs are plentiful, and employers are having a hard time finding candidates to even apply for those jobs. So leaving a job without having another lined up would definitely be a mark against you if you were asking the court to give you some relief from your child support. Okay, next question. My ex had a baby and I'm not sure it's mine. Should I be paying child support? So that's a really, really good question. To be obligated to pay child support, you typically have to be a natural parent of the child. I mentioned step-parents aren't obligated in most circumstances to contribute to the support of someone else's children. So there's a couple of ways to establish paternity, and that's what we're talking about here. So paternity is established in a couple of ways. If you acknowledge paternity at the birth of the child and you did the affidavit acknowledging paternity and your name is on the birth certificate, that is legally sufficient proof that you are the natural parent of the child. Now, if that's what happened in this particular situation, questioner, and then you later had doubts about that, your paternity, you could ask for, you could initiate a paternity proceeding, and then that would lead potentially to DNA testing of the child and both parents to see if you are indeed the child's father. So if you really do have a doubt, you should understand that you can't be required to pay child support unless paternity has been established, either by acknowledgement of paternity or by an order, we call it in New York, an order of filiation, which is a paternity order. And then you could challenge or make an application to set aside your acknowledgement of paternity if you have some serious doubts. Now, sort of helpful non-legal tip, there are very reliable off-the-shelf DNA test kits that you can buy that simply require a cheek swab from you and the child. So if you have access to the child and you really hold sincere doubts about paternity, even if you acknowledge paternity at birth, you could try one of those test kits and at least get a threshold. Those test kits won't hold up in court unless the parties agree. that you're not the father based on the paternity test that was done out of court. But that could be a strong argument to go petition the court to ask for the formal order of paternity from a recognized laboratory that the court would accept. All right, next question. How do I take my ex to court to pay for child support? We have a marital settlement agreement, but he isn't sticking to it and making all kinds of excuses when I ask him for the money. So that's a great question, because I know that does come up a lot. So if you have a marital settlement agreement and that marital agreement became part of your judgment of divorce, your judgment of divorce is a court order. So you can enforce that order, and you can do that through the Supreme Court in New York State that issued your judgment of divorce, or in the family court in most instances, which is a lot more flexible and quick and easier to navigate through the family court than it is through Supreme Court. If you just have an agreement and you have been living pursuant to that agreement, but nobody has made the next step to move toward getting a judgment of divorce, then you could take your agreement to Supreme Court and bring a contract enforcement action. You could say that the other party is in breach of contract. Most of those agreements have a clause in them, if they were drawn up by a decent attorney, that say if the other party breaches and the party who is suffering as a result of the breach has to enforce it and they are successful, the breaching party would owe legal fees to the non-breaching party. So keep that in mind, because you could get your counsel fees paid for at the end of the line if you have a contract that states that breach entitles you to an award of legal fees for your reasonable legal fees to enforce your rights. And you could also just simply petition outright in family court, include your agreement, and ask the family court to give you a family court order of support that the other party must pay in accordance with their agreement. So I hope that helps. The next question is, what is the basic New York State child support obligation? And I think I addressed that when I talked about the formula we have for combining the incomes, taking off the Social Security and Medicare and self-employment taxes, running the proper percentage based on the number of children, and then assigning each parent their pro rata share. So that basic child support payment is the monthly or weekly or bi-weekly payment that comes out of the formula in New York State. Question number 15. Can a judge make an exception to my case? I have special needs and need my child support reduced. Yes, theoretically, the judge can always take into, our statute says, in any other circumstances that the court considers relevant to the determination of support. So the formula is, fairly straightforwardly applied in most circumstances, but there is room for both parties to argue that there are special circumstances. So sometimes a parent is arguing that they have a greater need for a higher number in the support arena than the calculations would yield, and some are in, as this questioner is saying, in special circumstances that might warrant a reduction in the child support obligation. So that's a long answer to yes, special circumstances or the unique circumstances of your situation can be considered by a court. What if my ex moves to another state? Must he then still pay child support? Absolutely. So the fact that your ex moves doesn't mean your children don't need a roof over their head and have food every day on the table and have a reliable vehicle or form of transportation to get them where they need to go and get health care and all that sort of thing. So that should have no bearing on the obligation of your ex to continue to pay child support. And if you are having your child support collected through a child support collection unit, then they will follow your ex to wherever that person goes, so long as there's a trail, as long as they can find a new address, a new employer, etc., and continue to collect the support even though the parent is not in the state any longer, the state where your order arose. Does child support end automatically when my child turns 18 or 21, or is there a court document I need to complete? So understand that New York is in the minority and that our support continues until age 21 unless a child emancipates sooner or the parents have some other agreement about when support will end. But it does not end automatically. So it's really important that you anticipate the 21st birthday of the child subject to the support order. Get your petition in maybe a month or even two, given court backlogs. Get it in saying my child's about to turn 21 on their birthday in a month or two, so that you can get that obligation stopped, because once it's paid out, it's kind of hard to get it back from the recipient parent. There are limits to how much the court can require what we call expungement, require a parent who received child support to pay it back. So you want to get ahead of that. And understand that if you have more than one child subject to the support order, every time a child subject to that order hits the age of emancipation, you have to file a new application. So if there were originally 4 children subject to the support order, and the first age is out, so it doesn't happen at any of those stages automatically. Even when you only have one child, it won't end automatically unless you bring something to stop the order. All right. Next question is, what if I need an increase in my child support? This is also really common, so I'm going to go through this in a little bit more of a teaching level of detail. So child support can almost always be subject to being modified if certain circumstances are established. And the reason behind this in New York is that we want the courts to have enough flexibility to adapt to changing needs of children and changing family circumstances, so that no child is left without fair support, or no payor of support is unfairly burdened with support as circumstances may change over time. So the ways you get into the door to have your support reevaluated, either moved upward or moved downward, there are three possible thresholds. You don't have to meet all 3 of these. So the first one is the passage of 3 years since the last time an order was entered. So you may not know what the other party's income situation is after 3 years, but you could just ask the court to open the door again and let you in, and then you'll have to exchange income and financial information, as I mentioned earlier when asking a prior question, and the court will determine if there is a need or a basis to adjust support up or down. The second way you get in the door, after if you don't have the 3-year threshold available to you, the second way you get into the door is that 15% increase or decrease in either party's income. So I talked about that earlier. You can have a voluntary decrease in income. You can have involuntary increases in income and get an adjustment upward of your support, like if you win the lottery. Or you have gambling winnings, anything like that. That's a basis to potentially have your support increased. And then the last one is any other substantial change in circumstances. And that's kind of purposefully vague, because there could be lots of things. We couldn't name them all in a statute that might really warrant a need to modify a prior order of support. So rather than our legislature trying to think of every possible family circumstances that could be a substantial change, suffice it to say it's a substantial change, not a small change, but a substantial change. So if you were sharing parenting time 50-50 with the other parent, and all of a sudden the parenting shifted to 75-25, I think we would all agree that's a substantial change in circumstances. If it shifted to 49-51, maybe not. So there's no hard and fast rule, but substantial is in the eyes of the judge who's considering your application. So be sure that you don't go in on the thinnest of changes in circumstances. You want to have, something that's, the judge can get their teeth into and say, yeah, I got this. This is a pretty big change in circumstances. All right? All right. Next question is, can I ask a court for child support if I'm still living with my child's other parent? Not really, because the court needs to establish a custodial and a non-custodial parent, and that might be hard. I mean, maybe you have a situation I can't imagine right now, where that could be clearly established, even though you're still sharing the same household, and especially if you're sharing household expenses. Somebody's buying groceries and the other person's paying the light bill. That gets to be a real, muddy situation. And I would say that you may not be in a position to receive an order that the parent you're still living with pays support to you. But I would suggest that you run this by a lawyer, because there might be something in the facts of your situation that would give a reasonable lawyer a basis to say something other than what I just said here tonight. I don't know all of your facts, so you might want to check that out with an attorney who can give you individualized advice. Do I still have to support my child who is in foster care? Yes. It may not be at the same rate you were supporting your child when they were living with the other parent or whatever and they got removed. But yes, if you have the means, if you are not yourself below poverty level or below the federal self-support reserve level. If you don't know what those are, you can Google the New York State Child Support Standards chart. You can get the whole chart, and it shows you, if I make X, here's what my support obligation will be, based on number of children. So download that. It's the New York State Child Support Standards Guidelines chart if you want to know about how much support you might be obligated to pay based on your income, and what the self-support and poverty levels currently are for purposes of New York State child support obligations. But since the Department of Social Services is providing for the support of your child while they are in foster care, you could and very well likely would be required to pay some reimbursement back to the Department of Social Services for certain qualifying expenses that they incur on behalf of your child who is in foster care. Does a step-parent have to help pay child support for a step-child? I kind of addressed this earlier, but if this is your question and you're coming on late, I'll just say briefly, not typically, but if the child is in receipt of public assistance, like housing assistance, heating assistance, food stamps, etc., or any Medicaid or Medicare benefits, then a stepchild who has the means to contribute toward those expenses could be obligated to pay some expenses. And it's in the form of a reimbursement back to the Department of Social Services for the benefits that were paid out on behalf of the stepchild. Next question. I am a grandparent and my daughter's ex-husband does not pay child support. I am caring for the children. Is there any way I can make him pay some back to me if he refuses to go to court? So, if you have a legal order of custody, then it is very clear that you would be entitled to receive support from either or both of the parents, for that matter. So you could make your daughter pay for you if you're the grandparent who's caring for the children and providing for their needs. When you say caring for them, I guess I'm kind of assuming that they're living with you. If you're just providing child care, that's a different situation. Child care providers and family members generally cannot take a parent to support for the child care they're providing. But if the child is living with you, even without a custody order, if there is sufficient evidence that the child has been with you for a period of time and is anticipated to stay with you a period of time, such that the child is deemed living with you, then yes, you could potentially bring, again, both parents if you wanted to, but you could choose to just bring one to court and try to obtain support paid directly to you because you're caring for the children in your household. They live with you, or the child lives with you. Question 23, this is a good one, a good teaching moment as well. How is child support collected? So I made reference earlier that in New York State, unless you specifically waive your entitlement to have the support collection unit in your county collect the payments for you and keep a running log of all the payments in from the other parent and all the payments out to you, so they'll keep all that accounting and manage all of that. You can opt out of that. I'm not sure why you would, but they'll do all that hard work for you. They will also try to follow and find a parent who changes jobs or changes addresses in order to make sure that they stay on top of their collection on your behalf, or on your children's behalf, actually. So using the support collection unit has a lot of benefits. If the other parent falls into arrears, I'm not talking a payment missed here or there, as and as an unusual occurrence, but if it's regularly happening that the other parent is late or is just not paying at all, they can institute enforcement proceedings on your behalf. And in an enforcement proceeding, if the payor parent is found to have willfully violated the order of support, then but that means they knew of the order and they had the means to pay support, but they chose not to. And that also includes the means to earn income, but they choose not to. Then a number of things could happen to them. They could have their driver's license suspended. Not only in New York, but if they have an out-of-state driver's license, many states have reciprocity. So if our support collection says to Massachusetts or Vermont, we have a deadbeat parent over with children in the state of New York, and we would like you to suspend their driver's license in your state. That can happen. Hunting license, pistol permit, fishing license also can be suspended for a willful violation. When somebody is found in willful violation or they're in arrears, the support collection unit or the court can order that any tax credits, tax refunds from the state where they file their taxes, so maybe it's New York State or with the federal government, their refunds and tax credits can be garnished and taken right from the treasuries of the state or the federal agencies to satisfy your child support arrears. And as a tool in the judge's arsenal on these enforcement cases, somebody could be jailed for non-payment of support, particularly if the situation is egregious or the person is a repeat violator of the child support order. All right. Is it necessary to hire an attorney for child support issues? So I feel it's best for you to have an attorney in your corner, whether you are on the I want to establish a support order side of things, whether you are trying to defend yourself as the payor from only paying what you minimally are obligated to pay and not being, abused by the court system, or if there are enforcement issues and you are prosecuting the enforcement or defending the enforcement case. It's really important to have counsel in your corner assisting you. In some circumstances, as I mentioned before, the recipient of support can get assistance from the attorneys who support the county level support collection unit folks. If you are facing a penalty for a violation of a child support order, you are entitled to a legal aid or public defender type attorney to represent you, because there's a possibility that you could be placed in jail. So you are entitled to free counsel if you can't afford it. And in some counties, both parents can receive free or reduced fee attorneys through by making application based on income qualification. Okay, the next question is, what are some ways to get a child support order? That's also, I really, actually, when I read the question, I thought, well, that's silly. There's just one path to do that, but, there really isn't. So it's a great question, and I'm glad you asked it. So one way is to file a petition in family court if you've never had a support order and you have an established paternity of the other party. You could file a petition for support. If you haven't established paternity yet from the other party, then you would start by filing a child support application, but there's a box you will want to check on the form that says paternity has not yet been established, but I would like to have it established. So then you'll have two proceedings in one. The court will start with a paternity issue and resolve that, and then they'll move to support, assuming that paternity is indeed established, that the person you named in the petition is the father of the child. So that brings me to a point, and I want to mention here, and maybe my team helping me behind the scenes tonight can post in the chat. You can go to the New York State Court website and download fillable forms, and in some instances a do-it-yourself form for establishing child support, modifying child support, or enforcing child support. And the do-it-yourself forms step you through an easy-to-answer questionnaire. So it's very, very user-friendly. So you'll want to go to www.courts with an S, courts.state.ny.us. So courts.state.ny.us, and look for the tab on the home screen of that website that says Forms. And then once you're in Forms, it'll ask you, do you want family court forms or some other court form? So choose family court, and then choose the support or child support obligation or child support tab. And it'll take you right to all the forms you need if you are the do-it-yourself kind of person. So, and if you just want to see what they look like, so you want to decide whether you have the guts to do this on your own, you can check them out there. All right, what kind of income can be withheld for child support? So I touched on this earlier. I'll go through it again. There are a number of things that qualify as income, but our statute is very, very broad. So it might even be easier for me to say what's not income or what's not able to be garnished for child support. Veterans benefits and certain disability benefits are not able to be garnished for child support. Other than that, almost every form of income, so pension income, Social Security income, earnings, self-employment earnings, gifts from others, debt reduction. If you get your credit card debt compromised and you owe $20,000 to your credit card company, and they agreed to settle with you that if you paid $4,000, they would erase the rest of your debt. That $16,000 is income, and you're going to get a statement at the end of the year from the credit card company that you had $16,000 in income. All of that could get added. So I mentioned gambling winnings, lottery winnings, inheritances, income from passive assets like the stock market makes your investment portfolio go up and it pays you interest and dividends, that kind of thing. So income is defined very, very broadly. There's very few things that would not qualify as income for the purposes of calculating child support. All right. If you are being paid child support, can you also apply for spousal support? Yes, absolutely. So in order to qualify for spousal support, actually spousal support formulas are a little more complicated than child support, because there's two different formulas that the court would run based on your income and the other party's income. And then the results that come out of those formulaic calculations, the lower of the two results is considered the presumptively correct sum of support. So generally speaking, if there is a gap between your income and the other parent's income such that they make about 1/3 more than you, another way to look at it is if you know what they earn and you take 1/3 of it and you make less than 1/3 of that, then you probably do qualify for child support, spousal support. And you could make that application for sure. So the interplay between how much can the payor be required to pay if they're paying two forms of support is a little bit more complicated than I can address fully here. So you'll want to definitely consult somebody about your rights with respect to the spousal support plus child support question. It's a very good question. And then finally, I was wondering when we're going to get to the college expense question, because that comes up a lot for me. The question is, can I ask my ex to pay for my children's college tuition? So in our statute addressing child support in New York, college expenses are addressed as a discretionary option that any Supreme Court judge or child support magistrate can include. We don't have a formula for it, so it may not be the same, 17 or 25% of the other parent's income is what they have to contribute toward the college, or your pro rata sharing of other expenses like health insurance and daycare may not apply to the college expenses either. The statute quite literally says that the magistrate can order a parent to contribute to the reasonable college expenses of the child or children after considering all of the circumstances, including the parties' respective incomes and the the reasonableness of the child's bill. So that doesn't give you any specifics about how is a court going to approach it, because it's very can be very unique from one courtroom to the next, how the judge looking at those situations would address it. But do understand that contributing to college expenses for a child, even a child who's boarding away, does not eliminate the basic support from the non-custodial parent paid to the custodial parent. But if college expense contribution is awarded and it covers in part room and board, housing and food for the child while they're boarding away, the support court must not double charge the payor parent for room and board away and then pay child support for room and board to the parent who receives child support. So they would give you some kind of reduction for not doubling up on the room and board expenses. And I apologize, I can't be any more specific than that because it is a highly discretionary decision for the court. And unlike our child support, our basic child support statute, which has formulas and rules and how things are handled, it's much more mushy when it comes to college expense contribution. So that being said, I am going to look for a nod from my team if there are any questions that have come in through the chat while this is going on, because I have been focused on giving you the best information I can, and I haven't been monitoring the chat. So team, if you can let me know if there are things I need to address. It's not looking like it at the moment. So with that, I want to do as I promised at the outset and tell you about some really exciting things that we have going on to offer you tonight. So from now until the end of August, so I realize it's the 22nd, but it still feels like there's a lot of August left, we are offering through Whitson Law Firm a $200 discount off of prenuptial agreements. So we charge flat fee for the prenuptial agreements. Prenup agreement is perfect for people who are newly engaged or about to walk down the aisle sometime in the future. If you are already married, it would be a postnuptial. But we're talking about those people who want to make sure that they're thinking about, talking about, and documenting things like the kinds of things we're talking here today, so that they're walking into this relationship with open eyes. And I've mentioned the interplay about step parents and when do step parents, have to step up and pay. If you are blending a family, you might want to have a prenup that just talks about specifically how are you going to handle expenses for each other's children, because those can be things that sort of, if you haven't thought about and talked about and agreed upon in advance, can be areas of difficulty in your relationship or your new marriage. So $200 off between now and the end of the month. You just have to book your consultation and engage us for that. And even if the agreement isn't done until after the end of the month, as long as you locked it in, you're going to get your $200 discount on that. We are also running through the end of August at Whitson Law 50% off, 50% off of our consultation fee if you thereafter retain us. So you'll get that 50% rebated back to you in the form of a discount against the retainer for any work that you hire us for. And I guess it's a good time for us to say we of course do child support work, both for the recipient of child support and for the payor. So we handle all things child support and college expense related. We handle spousal support as a standalone or in conjunction with child support, if that's your situation. We do divorces, adoptions, child custody, grandparent rights, mediation for all types of family issues, and collaborative divorces. So we like to say we are a one-stop shop boutique law firm for all of your family law and matrimonial law needs. So you can check out our website. It'll be in the comments below, or call us directly. And our number is 518-412-4111. We also have a 24/7 chat on our website. So if you're thinking about it and or something arises on a weekend or an evening, shoot us a chat and we'll be sure to see that and respond within a reasonable time frame. Okay. I also want to remind you about the release of Divorce Done Right, A Better Way to Break Up. It's my new book coming out any day now. The next couple of days you will see it live on Amazon bookselling, and you can order and download the ebook, get yourself a hard copy, and soon get yourself an audio copy if you are an audio book listener and you like to listen while you're on your Peloton or in your car or taking your walk with your kids or your dog. And then lastly, we would be honored if you would like and follow us on all of our social platforms. We're so glad you found us here on Facebook, on our Whitson Law Firm Facebook page. But please, we like to reach as many people as possible. We're putting out this free information in the world just to be a helpful resource for people. We know it's not easy to take time and find the right attorney and get just basic answers to your questions. And maybe you just want answers and you're not sure you need a legal consultation. So that's why we're doing these events, and we want to reach as many people as possible. So if you like us and follow us on our social platform, Facebook and Insta and Twitter and all those places, they somehow get us in front of more eyes. So thank you so much. I'm going to take one final look at the chat and see if anybody has any lingering questions, and it does not seem so. So with that, I am ever so grateful that you took the time to be with us tonight. I hope you got real value. Please comment or give us a review on Facebook so we can know what you found helpful and what you might want us to do. Another topic that we can do a Facebook Live event like this on, or if we missed the mark on something tonight, we want your feedback about that too, so we can constantly get better and put more useful information out in front of our audience. And we're here for you folks. Thank you so much. We are very, very grateful. And I thank you to my team behind the scenes, Carly-Ann and Joshann, for helping to put this together and moderate for me. And again, I apologize that not Carly-Ann and Joshann, but me at my home office here had a little bit of a technology glitch. But we got through that and got to spend some time with you tonight. So thank you, good night, Godspeed, and we hope to see you on our next event.